following program on Other Derana 24 is classified for general audience. It is intended for all ages. It contains little or no violence, no strong language, and little or no sexual dialogue or situations.
Tonight, we discuss the intricacies of copyright and protection of content in the digital age. How can one protect themselves against online piracy, and have there been reinforcements to the already existing legislature? A very good evening and thank you for joining us on yet another episode of Law, Land and Liberty, where we break down key legal issues for the layman. Now, this topic is a topic that has been approached previously in one of our previous programs as well, but I believe with the advancement of the digital age and the new introductions of software that we haven't seen before, it's high time we do a little bit of an update on the current situation, and that is on copyright and the digital age. Now, I'm sure you would have, if you are a loyal viewer of the program, have seen our intellectual property discussion as well. Tonight we're going to go in a little bit deeper than that and explain specifically in the digital age how you can protect your content, or maybe you want to erase content, how that process completely goes about. And to speak about this, we have someone that is not a new face on the show, and that is attorney at law Thishya Weragoda. So thank you very much once again taking time out of your busy schedule to speak to our viewers and to enlighten us on this topic because it is very vital that we do so.
Thank you for having me.
All right, well, before we go into any of the discussion, let me give you a small breakdown on how exactly this topic is going to be broken down for you tonight. First, we'll be talking about the very basics. Are there specific laws for digital content, copyright or protection of content, and the digital age in relation to copyright in comparison to what we did previously. Next, we'll be talking about the current context and if there are remedies that have already been put in place and if there are reinforcements to existing legislature. And finally, we'll be talking about the future of content creation and content protection in the digital age.
Hello, my name is Suri and I'm a computer science student. My question is on copyright in the digital age. How has the laws on copyright changed over the years to accommodate the emerging technology?
All right, well, without any further ado, let's get right into this very packed discussion. So now there's a lot for us to break down, especially considering how vast the topic is, but of course we're going to have to limit it a little bit for specifically content creation and copyright digitally. Now, could you please explain to us, with the coming of the digital age, how has the concept of copyright and protection of content been transformed? How does it look like in a legal sphere?
Well, I think the basics remain the same. The idea, whether it is in the digital arena or in the analog arena, the idea remains the same, the principle remains the same. That is that whatever that I create, I will hold copyright to. Whatever content that you or I as an employee would create would belong to the employer. So the same concept would go on. So in the digital age, when you look at how things have to be adjusted, for example, we create content for various social media entities. All of those entities would have their own little set of terms and conditions under which we will subscribe to that particular platform, whether it is Facebook, whether it is Instagram, TikTok, whatever you name it. So what happens is, all those platforms will say your rights and liabilities when it comes to copyrighted content. So if I create a content and I upload it, if you decide to download it, you will be violating my copyrights in the general sense. If you upload it, then you are creating another copy, which is prohibited by law. So what will happen is, the platform itself will say, hang on, you can't do that. If you do it and the rightful owner complains, you have to take it down. So these platforms itself will provide a copyright protection mechanism. But on the other hand, if we look at the basic principles, the basic principle remains the same. That is that content that I create, I will own. The reason behind that is, whether it is a digital arena or whether it is still the analog world, the creator is a human person. Now I'm emphasizing on the word human because we now have another problem where it is AI driven. So who owns AI driven content? That is another minefield that we will have to navigate through at another point of time.
Right. So there is a very specific, well, more than specific, there is a little bit of a, at least there is some more protection given by the platform in itself when it comes to the protection of copyright. But sir, in your opinion, do you believe that traditional copyright laws are more stringent in comparison to whatever copyright regulations have been?
I would say that the law is the same. Like now, for example, throughout all around the world, copyright law is universally the same, one and the same. It's based on what we call the Berne Convention. So the Berne Convention was, if I remember right, 1893. How to protect literary and artistic works. So that principle has spread around the world, and universally there is protection. So for example, if content is created in Sri Lanka, used by someone in the United States, in view of the Berne Convention, we can go and sue in the United States for copyright infringement. You see, that's the beauty of copyright. Copyright is by its creation, not by any form of registration. By itself, by the fact of creation, copyright protection is there. And you create it in one country, it will go to the second country, the third country, the fourth country, wherever in the world, where it is a Berne Convention country. So we take the internet. It's the same principle. It could be, the offender could be in any country in the world. But you see, in the United States, where most of these tech companies are based, they have something called the Digital Millennium Copyright Act. This was created somewhere in the 1990s, late 1990s. That says that the protection can be additional. There can be additional protections. For example, if you can go and register your copyright, saying that this belongs to me, and then somebody else uses it, there are statutory penalties, very serious penalties. So in the US, you can actually have higher penalties if somebody uses this copyrighted content on the digital media.
All right, sir, I think we should get into a little bit of a technicality aspect. Well, not technicality, but when it comes to the protection of content creation, we've seen a lot of gray areas. Could you please explain to us if, like in current legislature, has there been any addressing of such gray areas, especially when it comes to the digital sphere? It's very tricky to navigate.
Yes, so if you look at countries like Singapore, UK and the US, these countries are at the forefront of progression of laws when it comes to these sort of things. And Sri Lanka definitely isn't one of those tech-savvy countries that would just push through new laws. Sorry. So, I wouldn't say that our laws have progressed. But what I would say is that our law is wide enough to sort of adjust and adapt itself to whatever the technological advancements. You see, when the law is very generic and it's open-ended, it's easy to navigate yourself. If the law is very specific and focused on particular items, with the changes of technology, it would be very difficult for the law to adapt. And we all know that when it comes to technology and law always plays a catch-up game. So I would say that although our law is a 2003 based law, it's drafted in such a way that it is technology neutral, I would say. It doesn't matter what the technological changes are, the copyright law is wide enough to cover it. Of course, having said that, I would say that if we do make changes, it might make things a lot easier, a lot more user-friendly to the content creators. But be that as it may, I think that the present law covers the bare necessities so that they are all protected.
Right. So another question to follow up on that is a question of curiosity. Now we've seen, of course, it's not always just about protecting the content creator. Sometimes there needs to be certain protections given towards people that are trying to use what is claimed to be copyright free and what is claimed not to have had any strikes on copyright as well. So do you believe that the current legislature that exists strikes an accurate balance between the consumers and the creators?
Yes, so I would think that if we look at the existing law, it provides what we call what we call as the fair use exceptions. So these fair use exceptions makes room for you to publish something that is the news of the day. For example, I take a photograph of something that has happened, which is news of the day. You can use it without my permission. Or let's say that I buy a CD. Nobody buys CDs now, but let's say that I buy a CD. I can make a copy for myself as a backup to keep, but I can't give it to anybody else. So likewise, there are certain exceptions. If I'm a teacher, I can copy part of a book so that I can distribute it in class, but I can't ask the students to pay me money. So likewise, there are what we call acts of fair use. Now you see these acts of fair use come into play from the Berne Convention that I mentioned, 1890s. Of course, having said all of that, I think we must also recognize that there are certain other problems both consumers as well as content creators or media institutes face. 30-40 years ago, you wanted to purchase some music. You would just walk into a record bar, buy a cassette, come home. Something that only very few of us in our generation have done. I'm sure you probably wouldn't have done that.
Wouldn't relate,
but I do remember in the early 90s, when music comes up, you get those cassette players, 90-minute cassettes, 45 minutes on one side. You go and buy it. Then all of a sudden in the 90s, mid-90s, Sony created the Walkman. Sorry, that was in the late 80s, Sony created the Walkman. So we could record the cassette, put a Walkman, headphones, go around. That's why it's called a Walkman. And then Sony came up with a CD version of it. And then people started, instead of having cassettes, copying music onto CDs. And then the internet boom happened. With that came Napster. Then came Aimster, Grokster, several other places. Websites where you could convert music into MP3s. Right? So you had a cassette converted into an audio file, shared all over the internet. You download some sort of app, and then you listen to that music. Then came the iTunes, the Apple iPod, digital version of a Walkman, right? 4 GB of data. That's hundreds of songs. And with that, they realize that they have a serious problem. A cassette, the number of copies that goes around is minimal. But with the internet, these songs get copied multiple times everywhere. So in the early 2000s, I think, Sony came up with this great plan, what they thought a great plan. They put a small software, a sort of a virus, that prevented people from copying their music off a CD onto your computer. And it was held illegal. This is called the Sony rootkit problem. So likewise, every time the technology advanced, owners of content tried to prevent the abuse of it. But then ultimately now, if we want to listen to music, we don't have to pirate the music anymore. Spotify or Tidal or whatever you call it, you can just subscribe and listen to the music. Whatever the technological obstacles that people face, they also find a solution. But back then when we bought the cassette, nobody asked for your name. Nobody asked for your credit card number. Nobody kept a tab of what sort of songs you listened to. But today, I subscribe to Apple Music or whatever. They will keep tabs of my account number, my email address, my gender, my age, all my personal identifiers. So, along with me purchasing that music, they decided to figure out what sort of music I like on the basis of predicting better songs for me. But what they're doing is they're profiling me. They're collecting sensitive information about me. So, of course, there's an economy there. On the other side, the consumers also have concerns. My credit card details, so everything is there. So, there has to be a balance that is achieved. And without that balance, I don't think the entertainment industry could ever survive. I always say that it takes two to tango. And in the music industry, if you keep on suppressing the consumers in their aim to protect the content, the consumers might say, no, we don't want it. Or if you give too much, the artists will suffer. So it's a very delicate balance that we have to strike. And I think that our law does that, but not through sophistication, but through simplicity.
I see. Of course, considerably it's lagging behind, as do all laws when it comes to technology, as you mentioned earlier as well, sir. Now, a question that is a question of curiosity, basically. When it comes to forms of media and when it comes to forms of digital content, do you believe that there is some sort of primacy given to one form of content being copyright protected over the other? Do we see things like that in the public space?
I'm sorry, I didn't understand that.
When it comes to the protection of certain forms of content, so video content, there's music, there's images, do you believe that the legal system has been defined in such a way or screwed in such a way that we see more protection for one form of content production over the other?
Technically, no. But the issue in a country like ours is copyright content related litigation is very minimal. So these things don't get assessed very easily. But of course, recently there was a couple of cases where the use of one photograph, a photograph just across the street actually, of the Nelum Kuluna, a rainbow over the Nelum Kuluna, used by a newspaper without consent, was awarded 1 million rupees of damages. And in another instance, again, 1.5 seconds of time-lapse video used by a media entity for publication, just for some promotional material, resulted in the 750,000 rupee damages award. So courts are giving money. Courts are recognizing that this is all hard work of the content creator, and they should not be used without consent. Of course, these cases are few and far in between. So I think that's where the problem is. Because of that reason, people are not very keen on really worrying too much about it. Everybody seems to think that we can violate it because nobody will go to court. So I think that's where the problem is. But other than that, I don't necessarily think that the law will recognize one medium over the other. As far as the law is concerned, all of this is either copyrighted or not copyrighted. They are not going to distinguish between the quality of the work.
That begs to question about the nuances of certain forms of content. For example, user-generated content. Sir, could you please explain to us how social media platforms have impacted the enforcement of copyright when it comes to user-generated content, as well as, well, basically, the using of certain original works and then replicating it on the social sphere, which we see all the time. Could you explain to us if there are certain extra additional nuances to that in the law?
Certainly. So if we take content that is on social media, for example, 2015 World Cup, in the Pakistan something cricket match, there was a guy who was very upset and kept his hands on the hips. Now that became a meme world over. So I don't think whoever the photographer can ever claim that this is my work, I want money every time somebody else uses it. Simply because it's being used for a fair purpose. You remember I earlier spoke about fair use? So fair use also recognizes criticism, review, also making parodies. So making memes also comes in there. So if you use somebody else's content to make a meme, that can't be considered as a violation of copyright, because the purpose is to make fun, not to earn money. So as long as user-generated content, when it's being copied, it's for a not-for-profit or a revenue-generating enterprise, generally it is considered as fair use.
So if by any chance someone tries to monetize certain things that are in the public domain right now, so if we try to monetize a meme, for example, that has already gone viral on certain platforms, that would be completely a hard line, no?
Not exactly, but if it is in the public domain, then there can't be any protection, right? There can be things in public, but still with the copyright. So just because somebody uploads a photograph to a social media platform doesn't mean that he's relinquishing copyrights. So if you are going to use it, you have to approach me and obtain my permission. You can't ever say that, no, it was on the internet so I can use it. In fact, it once happened to me. I sometimes take photographs and I published a particular photograph. A particular newspaper used it. And when I questioned them, they said, it was on the internet, we can do whatever we please. They can't. Because just because I put it on the internet doesn't mean that I lose my rights. Copyright, like I said earlier, by its own creation, gives me that right. And during my lifetime, and 70 years thereafter, it belongs to me and my successors. So nobody else during that time can monetize it. That's the basic principle.
All right. Well, there is quite a bit for us. There is quite a bit for us to discuss, especially considering the future of content protection and copyright, especially when it comes to increasing digital technologies such as artificial intelligence and using the blockchain. There's been quite some more developments as well, and we have to wonder if the law is really catching up as fast as it needs to. But before we discuss any of those topics, let's go in for a short commercial break. You're watching Lawland and Liberty. Stay with us.
Hello, my name is Thishya and I'm a law student. My question is on the future of content protection. How can the law strike balance between creators and consumers in the modern age?
Welcome back to Law, Land and Liberty. We are in conversation with attorney at law Thishya Weragoda, and we're talking about content protection in the digital age and copyright and the intricacies that are surrounding copyright as well. Now, so we just got in a very, of course, it summed up quite a little bit about the current situation as well and how it came to be and how copyright laws are not all too different across nations. So there is a little bit of universal consensus when it comes to the protection of content by creators. Now, I believe we should go into the more specific aspects of this discussion, which would be about the current context. Now, we've seen certain technologies arise over the past few years. It's been very rapid, and the essence of human creation has not changed as of much throughout millennia. So we see constantly new creations that have been uploaded onto in public or in public domain, which we just spoke about earlier. So could you please explain to us how technologies like blockchain and other emerging technologies, has it been any sort of contribution towards protecting copyright and protecting content by creators? Has there been has it been used so far, or are there plans?
Well, I would say that technology always pushes the boundaries of the law. And even in the situation of copyright law, certain particular types of advancements in industries has resulted with how copyright law is seen and viewed. For example, the number of years for which protection was originally in the 1600s was only 10 years. Right? That's because your lifespan was 40 years, so 10 years was a long time. But now our lifespan is 70 years, so the law has recognized that 70 years is a long time, where you need protection now even after your death. Now, technological advancements such as blockchain to artificial intelligence does pose threats and challenges. If you take AI, the question is, who should have copyright over such content? Is it the person who makes the query? Is it the person who uploads the relevant information to the AI system that should get that protection? So it's a very interesting time that we live in. I personally take the view that we don't need to always complicate ourselves. The answers are simple. Copyright only protects human creations.
So there is a hard line that we can draw when it comes to content creation specifically, because of course artificial intelligence, no matter how convoluted it gets, there has to be some form of human input.
Absolutely. So I'll give a very simple example. I wonder whether you remember there was a photo of a monkey who took a selfie. So that actually went to court. So our law recognizes that whoever who creates the work gets the protection. So in this case, the monkey pressed the button. And it's obvious that it's not a human creation. So because of that, the question actually arose as to who owns the copyright. Do you say that it's copyright free because an animal created it? Or do you say that the man who put all of that effort in to and created that environment, the animal trap to whatnot, do we recognize him as the creator? For some random reason, the US courts decided that it's the animal who has clicked, therefore there is no copyright to it. But I think that's not the best way to go about it. There is a man who put the effort to make it happen. And that man should get that protection. So on the same footing, AI also, the man who puts in the investment of time, energy and effort should get the protection, is what one school of thought is. The other school of thought goes on the basis, no, if AI creates music or AI creates a picture, there is no copyright to it. So there is a growing debate.
So there is a bit of a difference now we've seen in recent times as well. We've seen artists that are using, well, not just musical artists, but actual graphical artists as well, using artificial intelligence as a platform. They generate using keywords that they have entered. So when it comes to situations like that, of course, you have to fine-tune whatever output is given by the software that you are employing. Does that mean, depending on the effort and the dedication you put into that specific piece of work, if we could consider it as being able to be copyrighted or not?
So that would be the argument. In copyright law, one of the basic principles is that the effort doesn't matter in the sense, it need not be artistically or literally great for it to get the protection. A minimum level of skill is what is required. So a little bit of human labor to do it is what is required. Of course, me drawing a straight line is not art. But if I give my 5-year-old daughter to sketch around, it could be art. So that minimum effort is what is required. So if I use a generative AI to fill in a photograph that I have taken, and then I fine tune it, which includes my original photo also, I could possibly claim copyright for the whole thing. But if I just click a button and tell the AI to draw something afresh, there might be a problem in me saying that, okay, that's my work, because I just put in some words. Whether that is sufficient is something that court will finally decide. So for now, I'd have to say we don't have any authority on that in Sri Lanka, and I would guess to take at least 3-4 years for us to get there.
Right, so I'm assuming the same goes for written works as well when it comes to things like ChatGPT that we've seen writing literary pieces, same rule
Absolutely.
applies.
So the same principle would apply for the moment, but of course in another 5 years, how it would look like, your guess is as good as mine.
Exactly. With the rapidly evolving current climate as well, we really don't know where we would end up. But before we go into more specifics about
Anuradha, if I may add just one thing, I think again we have to go back to the basics, the basic principle. That's human interaction and human creation. So that would be the underlying thread even when it comes in another 10 years or whatever. I would assume that that would be the threshold issue. How much of human interaction is there? How much of human effort is there in the creation? So irrespective of how long it goes, that would be the deciding factor, I would say.
Right. Well, when it comes to human effort, now we've seen a lot of the greatest works that we've seen comes by collaboration. We've seen collaboration for over millennia of our human existence. How does the law define, or how does the law protect, especially when it comes to collaborative efforts and open source projects as we have seen, how does the law approach this specific issue?
So collaboration, the basic principle is if 2 or more people do it, they all jointly own it. Unless they have an agreement saying, okay, I do 50%, X does 25% and you do 25%. Then it would be in that form. But otherwise it would be in equal share.
So if there was a ruling in court and the total amount basically given as compensation, that would be split however way they agree to it, because they are considered one individual, right?
Absolutely. But when it comes to open source, this is sort of like a rebel movement, like the Star Wars. It's like the rebel movement of copyright protection. Some of the literature talks of it as a copyleft movement, the antithesis of copyright. So what they say is that, yes, it is protectable, but instead of claiming it, we open it up. So in copyright, we get this concept called Creative Commons. So when it comes to Creative Commons, you can license it to be used in various ways. I take a photo, I say, okay, instead of saying copyrights reserved, I say CC. And in that I can say, you can share it without a problem. No problem, you can share it. We can say, you can't monetize it. We can say, no derivative works. You can't use this as a foundation for something else. You can say share alike, so public can share it for information or whatever. So that sort of regime is also now quite in use. However, I think that is also recognizing the concept of copyright. Because there is copyright, there is a movement that says, okay, we are going to let you use it for free, or for these purposes for free. So, but that does not necessarily mean that you're coming out of that regime. So, open source also is on the same basis. You keep the technology open for anyone to use it for their product. And how you monetize it is on that agreement between the open source provider and whoever the developer who is going to develop. So, it's the same principle.
Right. So in light of that, we need to consider now open source is, as you mentioned, almost it's just a show of defiance almost when it comes to these stringent rules of copyright and content claiming. Now, do you believe that in the digital sphere we should have stricter or more lenient regulations in relation to things like open source and sharing content online?
I would say human progression happens on the basis of sharing information. I don't think there should be a restriction on sharing of information. The issue arises, and rightly so, is when somebody starts making money off somebody else's hard work. So, whatever the restrictions that we place should be preventing that piggybacking. So, I write a book, why should I let you make the money out of it? Is the question. So, whatever, if I publish something online, or if you publish something online, why should I make money out of it? It's your hard work at the end of the day. So, that prohibition or protection should only be for that. So, I take a photograph of something that is very nice, everybody admires it and everybody starts sharing it, there shouldn't be a problem. The problem would arise if X downloads it, uploads it as if it's X's work and tries to take credit for it. So, I think that's where we must realize that the real problem lies in sharing content on social media.
There is a lot of issues when it comes to sharing. Of course, as you mentioned, sharing is essential for the growth of the global population as well when it comes to intellect. There are certain issues, of course, relating to that as well, but that is a different discussion for a different day. Sir, now moving on to this specific, I believe it's not very clear to a lot of individuals, especially myself, the right to be forgotten or the right to erase your content from the internet or from the public, basically from public view. Could you explain a little bit about that, sir?
Sure. Of course, this is not exactly copyright related, but something that we discussed on a previous day on privacy.
Right.
So, as much as the internet tries to record everything that happens, like you mentioned, people have a right to be offline, not be recorded. But of course, at the same time, we walk along a road, we drive along a road, the CCTV cameras will catch us. We might not be able to be forgotten in public spaces. But in a private sphere, like for example, I go to Apple Music and I download some music. I should be able to say, hey, look, I don't want to be recorded in what music I listen to. Of course, that is why all sorts of internet browsers come up with incognito modes, so that there is no record of that browsing. And then we realize that no, still the ISP can have that information. So then we have something like the Tor browser or something which provides you a higher degree of anonymity. But all of that relates to our right to have a private life in our private affairs. So I believe that that is more of a privacy and a data protection issue rather than a copyright issue. But just because we put content onto the internet And just because we own it doesn't mean that there won't be a record of it. So the moment we put it out, yes, we have our copyrights. And part of that right is our right to decide how the public consumes it. We say that in terms of Section 9 of the IP Act, we have a right to decide how our copyrighted content is communicated to the public. So that right, we should be able to take it back also. So I think in answering your question, just like we give it, we have a right to take it back and say, no, I don't want that on the internet anymore.
Right, of course. Well, unfortunately, while we had a lot more to discuss as well, time has come against us. We were just getting into a topic that could potentially be explored in the future as well. We hope to have you back on the show as well. Thank you very much, sir, for taking the time to explain this very vast topic in more simplistic terms so that all of us watching can understand. Thank you very much for taking the time.
Thank you very much for having me.
All right, well, the digital age has brought about a plethora of new issues to the table, especially in means of personal expression and creation. We must be vigilant as to prevent any infringement upon our inherent rights to create and protect such creations. We leave you tonight with the words of Shepard Fairey, an American activist and artist. The most important thing about intellectual property versus creative expression is that copyright law was created not to stifle creativity, but to encourage creativity. That is all we have for you on Law, Land and Liberty. If you have missed any of today's programs, you can always rewatch by catching us on our YouTube channel, youtube.com/OtherDerana English. Thank you for watching. Have a great night.